Right. I feel normal during the day, but at night, no.
It's been a pleasure. Nice to meet you.
All right, so same rules apply with this guest speaker today, and I'll let him introduce himself here in just a second. I will put the assignment in Moodle, and you should see Jen's in there. So I know someone messaged me, I don't remember who it was, saying, hey, you didn't put the assignment in Moodle. I did put the assignment in Moodle, so if you have your papers typed for Jen, just go ahead and upload those into Moodle. So this is our third guest speaker, and it'll be in Moodle like that as an assignment in there, okay?
Do you have your speaker?
Okay, he came prepared.
Awesome. I'll just send it on my computer.
If you need more, young lady, let me know.
Thank you.
All right, floor is yours.
Thank you very much.
Yeah.
Thank you all for having me here today. Melissa, thank you for
Yeah.
asking me to come also. My name is Steve Vitale. I'm an attorney in Michigan. I've been an attorney since 1991.
How do you spell your last name?
It's V like Victor, I, T as in Thomas, A-L-E. Just a couple of ground rules. Anyone wants to ask a question, interrupt me at any time, please do. Just raise your hand. I'll be happy to answer any and all questions anytime you have them during the presentation today. What I was hoping to do, knowing what you folks are here for, is go through a few things regarding the criminal justice system in Michigan and try to relate them as best I can to what you folks are learning here in your criminal justice class, so that hopefully one day when you're out of the classroom and you're actually at an internship or you're in a job somewhere, that you'll be able to apply some of these things and remember some of these things so that they can help you in the future. I thought a good starting point would be procedure in Michigan court. And Melissa, I'm going to assume probably you've covered a lot of what I'm going to talk about. Sometimes I'm trying to get the more practical aspect. If there's anything you wanted to ask, please do.
The goal of this class, the students in this class make up, I feel like, the kind of broadest population of a class here at KCC, because there's some, it's just, I'm in high school and this fits into my schedule. Some want to go into criminal justice, and some are only here because a friend joined the class. You know, there's all different varieties. So I think this class is beneficial for everyone to take, because the purpose of it is to give an overarching kind of view of the flow of criminal justice. So the main objective of this class is for students to understand how and when a crime is committed and reported, all the way through the flow of criminal justice and what that process looks like. So in our textbook, it breaks that whole flow down, chapter by chapter by chapter, and some of it is the procedural aspect of it all. So it's very kind of just touches on every step along the way.
Great.
So, and at the end, they have to pick a case that is already completed, closed out, that's gone all the way through circuit court, and the person has been off to prison, and they have to be able to identify some of the key factors of that case. Date the time was committed, when they were arrested, what was their bond when they were booked into the jail, when was their arraignment, when was their prelim, when were they bound over, you know, the whole entire flow of the process. So
sounds wonderfully practical. Yeah, that's exactly how it happens.
So that's kind of the
life.
goal of what they learn in this class by the end of the semester.
Maybe a good way to start then, thank you very much for that, Melissa. A good way to start is to try to understand how everything fits into the criminal justice system. So let's, for a real short time, talk about separation of powers in the three different branches of government in Michigan and how they're going to relate to a criminal justice case or system. There's three branches that we have in government. One of the branches is the legislature. The legislature in Michigan consists of a House of Representatives that's 110 representatives and a Senate that's 38. Now, what does the legislature do? The legislature passes laws. They'll determine what's legal, what's illegal, what you can be arrested for, what you can't be arrested for. The legislature will define the elements of the crimes quite often. Sometimes they'll leave it to common law and a court will define the crime. But that's one area, is the legislature. The executive branch of the Michigan government is headed by the state governor, which I'm sure everybody knows here now is Gretchen Whitmer. And then there's the judicial branch of government, which the judicial branch in Michigan says there's one Supreme Court in Michigan, and the Supreme Court is the head of the judicial branch. And then there are other inferior courts, the ones that you'll be dealing with most of in this class are your district court where everything will start, and then the circuit court where a case will usually go on and conclude at. Now, the reason I want you to understand all the separations of powers is because we have this idea of separation of powers that if you belong to one branch of the government, you can't belong to another one. You got to be in one. You can't be a legislator and a judge, or you can't be a judge and the governor. If you're serving in one of the branches, you got to serve in just that branch. So once we understand all the different areas that branches of government and how they fit into the criminal justice system, now let's talk a little bit about procedure. As Melissa said earlier, let's start with a crime is alleged to have been committed. Well, what happens? If a crime is committed, someone will call the police, and the police usually, and they have one here also in the Calhoun County, the head law enforcement officer in Michigan in a county is generally the county prosecutor is who it is. That's the person who actually decides what to charge somebody with, whether they're going to charge a felony, whether they're going to charge a misdemeanor, and they're the person responsible for following the case all the way through the court system. Now, there is also in every county in Michigan a sheriff also. They're generally head of the sheriff's department, which is tasked with running a jail. The sheriff always has to run a jail, as additionally providing police services for counties, cities, or townships that don't have their own police department. You often listen to the sheriff's department will provide within a county services for a township or a village or somewhere, a smaller unit of government that can't afford their own police department. So let's say hypothetically that's where we start. A crime is alleged to have been committed. Somebody calls the police will come out and investigate. They will interview witnesses. They will sometimes take photos. They'll quite often gather any evidence there is. If a officer thinks they need a search warrant, they will go to a magistrate to get a search warrant, or a judge. And maybe one tidbit that you might want to know: in order to get a search warrant, they have to show probable cause that what they want to search is going to have some kind of evidence of a crime. The theory or the thought process during an investigation of a search warrant is a Fourth Amendment concept to the United States Constitution. And just out of curiosity, Melissa, have you gotten yet into this class into any constitutional law about a corporation doctrine and things of that nature?
So there is one chapter earlier on in the textbook that goes over rights and talk about the Constitution. But it's, again, this class is like skim the surface of every kind of topic to get through the entire process. So.
Good, okay. So remember that when we talk about search and seizure, trying to seize either someone's person, or more importantly, the most common way is to try to get a search warrant to enter a home. That's what you need in order to get a search warrant to enter a home. You need probable cause to believe that there's evidence of a crime at a building or dwelling, and a search warrant. Know from United States law that if the police enter into a home without a search warrant, that is a presumptively invalid constitutional entry into the home. That if you enter without a search warrant, then the government has the burden of showing that there are one of the exceptions that a warrant requirement has. One of the biggest exceptions of a warrant requirement is consent. Police will often ask people if they can consent to come into their home and let the police not have to get a warrant. Different opinions on that depending upon whether you're more pro-law enforcement or whether you're more pro-defense and rights, but quite often you'll have many people tell you don't ever give the police permission to come in your home unless they have a warrant. Some people will take the other side and say, well, as long as you have nothing to hide, there's nothing that the police can find, go ahead and let them come in. That is probably the biggest exception to the warrant requirement is consent. Some other exceptions to the warrant requirement are emergency aid. If the police feel like somebody is in need of emergency aid, they can enter. If the police feel that there's exigent circumstances, meaning there's some kind of destruction of evidence about to take place, they can go in without a search warrant. But generally, even if the government can show one of the exceptions to a search warrant, generally they have to still, once they get in, cordon the place off, get everybody out, and still have to go get a search warrant and wait. Generally, entries into a home, if they're not consensual, are only to go in and make sure that something doesn't happen, like a destruction of evidence or somebody's harm. If the police still want to go ahead and go through the entire dwelling, they still need to go to a judge or a magistrate to get them to sign off to let them go in. Now, another question about search warrants. A judge or a magistrate anywhere in the state of Michigan can sign a search warrant for anywhere else in the state of Michigan. Say, for instance, here in Calhoun County, the police wanted to go in somewhere and wanted to get a search warrant. And they called a magistrate or a judge that wasn't available. They couldn't find a Calhoun County judge or magistrate to sign a search warrant. They could go over to Jackson County or Kalamazoo County and have a judge in one of those places sign a search warrant to allow them to enter. So let's assume they enter, gather any evidence that they think they have, and the police make an arrest. What happens after an arrest? Well, for those of you, and as your instructor Melissa has said, I'm glad to hear you got a good cross-section here. One of the first things you have to know to make an arrest, okay, is there's an arrest statute in Michigan, okay? And then there's some constitutional law on it. Constitutionally, the law says if the police have probable cause to believe a felony is committed, they can make an arrest. Police do not have to see a felony committed in their presence, as long as they have probable cause. Also, any misdemeanor committed in the presence of an officer, generally the police can make an arrest also. Maybe the statutes that I told you about earlier that a legislature would pass in their branch of government, in Michigan they are called the Michigan Compiled Laws, sometimes abbreviated as MCL. One that you should familiarize yourself with regarding arrest is Michigan Compiled Law MCL 764.15. And maybe you want to write that one down so that you have it, 764.15. That statute goes through very specifically, paragraph by paragraph, section by section, subparagraph and subsections, exactly when you can make an arrest in Michigan. And it's an important statute to know because one, if any of you in here are planning on becoming police officers, you're going to run into that and you're going to run into that in your training. Or two, just to generally know your rights and what the police can and cannot do. So, as the police are investigating a crime, let's say in the case they think somebody's been shot or they think somebody's been assaulted. As they begin to investigate the crime, they can go to the local county prosecutor and ask for help. And by help, it's a very tricky tightrope the police and the prosecutor are walking because the police are supposed to be independent and do their own independent investigation. But they can go to a prosecutor and say, do I have enough here right now to charge somebody? And generally when the police take something to a prosecutor, what the prosecutor does is says, yes, I will issue the warrant against this individual that you have arrested or that you suspect has committed a crime. Two, they'll do what's called a denial of a warrant, saying, no, you don't have enough here to arrest somebody. Or three, they'll do what's called a furtherance. And the prosecutor will instruct the police, go out and interview these more people, or go out and see if you can get me more evidence of this fact or that fact to try to make the case more solid. If a prosecutor feels like, yeah, it looks like a crime has been done here, but not enough has been done yet, then we'll go ahead and ask the police to do more. Now, let's say the police either have done more and we get to a point where the prosecutor's office will tell the police, yes, we have enough here to go ahead and charge somebody, we will issue a warrant. Now, the charging document is often called an information or a general information, is what it'll be called. And that is what you will take to a court. And generally the way a case starts is a police officer, usually the investigating detective or officer, will literally go before a judge or a magistrate, and that man or woman who's the police officer will literally raise their right hand before a judge. They'll be sworn before a judge. They'll swear to tell the truth, and the judge will say, officer, what did you want to tell the court with regard to your request? And then a police officer, literally right in front of a judge or a magistrate, will recite everything they have. On November the 15th, 2021, we received a 911 call at the Battle Creek Police Department to come out that there was an assault in progress. Officers responded, and here's what they found. Officer A arrived and saw the victim of the case, John Doe, with a black eye, bleeding, bruises all over him, and asked him what happened. John Doe responded that so-and-so beat him up, and the officer asked how do they know each other, found out the relation between the parties, went and found, to make the case easy, went and found the suspect in the case, and the suspect in the case said, yes, I did beat him up, but it was self-defense. Now what you have is a judge or a magistrate, they'll say, yes, I'll issue that warrant, because something like self-defense that's a question of fact ultimately for a jury. Now, that is done usually the first time in district court, the local district court. Michigan, for the purposes of the criminal procedure, have district courts, which are local courts, usually a city or a township. Then they have circuit courts, which literally are at the county seat, wherever the county is. Like here in Calhoun County, your county seat is Battle Creek. And if I recall correctly, your Justice Center in Calhoun County, it's been a few years since I've had a case there, but they have the circuit court and the district court in the same buildings, and you'll have different judges in district court and different judges in circuit court. And how many judges you will have in a district court or circuit court will usually depend upon the population in the area that they're over, like say for instance here in Calhoun County, and the amount of cases that they have coming through. So it's their caseload and their population will determine how many judges they have. After an officer swears in front of a magistrate or a judge, the magistrate or judge has to make a determination. They will usually say, yes, I find, officer, by the statements you've made here on the record, there's probable cause to believe a felonious assault has occurred or an assault with intent to do great bodily harm. And that might be a good one. Let's go through that a little bit because that's in our hypothetical. Let's talk about assault in Michigan, how many different types of assault there are, okay? Generally speaking, there are 5 different types of assault in Michigan. There are 2 types of misdemeanor assault. One is assault and battery. It's in the alternative, usually assault or assault and battery. They have a separate Michigan, a separate domestic violence statute for that. And those are 93-day misdemeanors. Then in Michigan, there is aggravated assault, which is kind of tricky because in most states that you'll find, when you look around, aggravated assault is a felony. It's not in Michigan. In Michigan, aggravated assault is a 1-year misdemeanor. Now, what do you have to have for an aggravated assault? You have to have an assault. And what is an assault? An assault is either putting someone in fear or apprehension of an immediate battery, meaning you make them think they're going to be harmed, or the battery itself where they actually strike somebody. And that's why it's charged as assault or assault and battery. What is an aggravated assault in Michigan? An aggravated assault is an assault with an injury, because a regular or 93-day assault, which sometimes people refer to as simple assault, does not require any injury. An aggravated assault does. It requires injury where somebody had to seek medical attention. If you have an injury and you had to seek medical attention for it, that's a 1-year misdemeanor. Then in Michigan, there are generally 3 grades of felony assault. The first grade of felony assault is literally called assault with a dangerous weapon or felonious assault. That is a felony in Michigan punishable by a maximum of 4 years in prison. And what is it? It is an assault, meaning we take the simple assault with a dangerous weapon. Okay? Obviously, what's a dangerous weapon? Some things are easy. Guns, knives, striking someone with a baseball bat, those are the easy ones. Sometimes it gets a little more foggy because Michigan has what's known as an instrumentality test of something being a dangerous weapon, meaning how did you use it? There's literally out there one case that came from the Michigan Court of Appeals that says a booted foot can be a dangerous weapon no matter what, if it, depending upon how it's used. You know, a microwave that you have sitting over there, if you take it and strike somebody over the head with it, that can be a dangerous weapon. So whatever is a dangerous weapon can be just about anything. It depends how it's used. That's the lowest level of felony assault. Then after felonious assault, the 4-year, there is a 10-year assault. It's called assault with intent to do great bodily harm less than murder. And again, a lot of these things will be decided at some point by a jury or a judge acting as a trier of fact. And if you can show that, that's a 10-year felony. And then there's the highest form of assault in Michigan, which is assault with intent to commit murder, which basically the prosecution has to show that you did commit an assault and that you intended to kill the person that you assaulted. That's a felony punishable by a maximum of life in prison. Now, what happens after an officer swears to a warrant? Let's just say in this assault case that we have. If the person is in jail already, they'll bring the person over to get arraigned. If the person's still at large, the police will then go out and try to find this person, whomever he or she is, and arrest them. Once the person is in custody, once there is a warrant and someone in custody, generally speaking, that person has to be arraigned within 72 hours, max. Most police departments will do it sooner than that, but they've got to do it within 72 hours or let somebody go. And you will hear this term sometimes in legal procedure and police work where they do release somebody because the police don't know if they're going to get a warrant or not. And they'll call it an RPI. And RPI means release pending investigation. Okay, it means the police and the prosecutors aren't done yet determining whether they're going to charge someone. So a person charged with a crime, anyone we know, if it were any one of us, you appear before a magistrate for arraignment. Now, what is an arraignment? An arraignment is the first adversarial judicial proceeding that you will have in the legal system. An arraignment will take place in front of a judge or a magistrate. There are two main purposes of an arraignment, and this is really what you should know about an arraignment. One, to inform the person what they're charged of, because everyone has a right to know what they're charged with. And second, to set a bond or a bail. Okay? Now, looking at these two things, every defendant who is charged has the right to have their charges read against them. That rarely occurs in open court. Normally what occurs is an attorney who's there with the defendant does what's called a waiver of the reading, a waiver of the formal reading of an information, and there are generally two pleas at the first arraignment. There is either not guilty or mute, and I'm going to spell that for you because a lot of people mix that up. Mute is M-U-T-E, and the reason I distinguish it, some people will hear it and think I'm saying moot, M-O-O-T, and I just want to make a differentiation between those two terms. Moot, M-O-O-T, means something doesn't matter anymore. Mute, M-U-T-E, means you don't speak, and that's what most pleas are. When I have clients that I bring into court for an arraignment, I stand them mute, M-U-T-E. That goes back to Old English common law, where you don't even dignify the charges with a response. You stand mute, meaning you don't even respond to it. You waive the formal reading, and then at that point, a magistrate or a judge will say to me or any other attorney counsel, ask the bond, what would you like the court to know? Okay, let's talk about bond for a minute. Bond, Michigan Constitution, Article 1, Section 15, talks about bond. That's the state constitution. Remember this one too. Michigan Court Rule 6.106F, capital F, 6.106, capital F in parentheses. That will tell you all the factors that are relevant for a bond hearing and what a court wants to know as to whether somebody should get out. So when you arraign someone, you would tell the judge things such as, Your Honor, my client's a lifelong member of the community. He's lived here forever. He owns a home in the community. He's had a job for over 20 years. He has a spouse. He has children here. He has deep ties to the community. What is the court looking for in an arraignment when you get arraigned? The court wants to know, are you a risk of flight? Will you leave while the case is going on? And two, are you a danger to the community? Now, if you're in this criminal justice class here, and some of you become police officers later, or some of you become lawyers later, you'll be familiar with all these things before a judge. And you'll tell a judge, my client, based upon all of his facts, all of his background, is not a risk of flight, Your Honor, or is not a danger to the community. If you're on the other side and you're the police officer, and sometimes you will have police officers or prosecutors present at arraignments, quite often it'll happen, you'll tell the court the opposite. Well, here's what I want you to know, Judge, to make sure you set a bond, a cash bond or a 10% bond. Bonds in Michigan generally can be a personal recognizance bond. And what does that mean? That means you don't have to post any money. The court lets you go on your own good word, that you'll promise you'll obey all laws, you won't leave the state, and that you'll appear for all court appearances. There is a cash bond a court can put on cash or surety, meaning they'll make you post money, or there's a 10% bond. So a court could say, after you go through everything with your client, counsel, I'll make your client's bond $5,000 personal. Well, a lot of people ask me, if a personal bond, you don't have to post any money, why does the judge put a dollar amount on it? The reason the judge will put a dollar amount on it is if you don't show up, that's what you owe the court. You'll have to pay $5,000 to be released then. Or they could say, a judge would say, counsel, after I've heard everything, I'm going to make your client's bond $5,000 or 10%, which means your client will only have to post $500. Or I'm going to make the bond $5,000 cash or surety. Now, what does it mean by a surety? Cash means obviously you could post the $5,000 immediately. Surety means a bondsman. There are people who are licensed in the state of Michigan to go to courts and post bonds for people. And what does the bondsman do? The bondsman or the surety posts a guarantee that if somebody leaves, they will pay the money that is owed to the court if a person skips bond. Now, what does a bondsman get out of that? A bondsman will usually charge for their fee of the services. If you have a $5,000 cash bond and you go to a bondsman and say, post a bond for me, generally the bondsman will charge 10%. The bondsman will say, well, the price to post a $5,000 cash or surety bond will be $500. And the family or the defendant will pay a bondsman $500 to post a surety bond for $5,000. So now we have been arraigned. Are there any questions to this point that anybody has about getting to the arraignment? Because now we're going to start talking about what happens after arraignment and we get to court. Any questions at all? Okay. After somebody is arraigned, the next thing that gets said is at the arraignment, the judge, after they arraign a person, will set 2 dates. They will set what's called a probable cause conference date, which will have to be within 7 to 14 days. And then they'll set a preliminary exam date, which has to be within 21 days. For good cause, those dates can be waived and go out longer. Now, what is good cause to waive those dates? Usually it's an agreement between the defense attorney and the prosecutor. Quite often because the defense attorney needs more police reports and doesn't have full what's called discovery. And you'll want to know that term, discovery. That basically means information that the prosecutor has to give to the defense attorney and the defendant in order that they can go ahead and be able to prepare themselves for the preliminary examination. Now, once the court sets those dates, here's a court rule that you're going to want to know too. MCR, and just so you know, anytime I say MCR, that means Michigan Court Rule. 6.110 E is in Edward, in parentheses, capital E. That's one of the sources that every defendant charged with a felony has a right to a preliminary examination if they want one. They don't have to hold it. They can waive it and proceed directly to circuit court. But know this, all the criminal cases will start in district court. And they'll start with that first arraignment in district court and a judge setting a bond and a judge setting those 2 dates, preliminary examination and probable cause conference. Probable cause conference is kind of just a formality. The prosecutor and the defense attorney will speak to each other. If they can work something out on the record, they can. More normally than not, if there's not going to be a plea that keeps the case in district court, a probable cause preliminary examination will be set. Now, what do we have to show at a preliminary examination? The prosecution has to show, just what I said, you'll find it in that court rule, 6.110 E as in Edward. They have to show probable cause as to 2 things. Probable cause that a crime was committed and probable cause that the defendant committed it. If the hearing is held and the prosecution cannot show those 2 things, the judge, whomever he or she is, will dismiss the case. Now, what could happen prior to that? Sometimes in district court, the prosecutor and the defense attorney can work out a plea agreement to a misdemeanor. When we talk about criminal justice and criminal procedure, the district court will handle all original felony arraignments, all preliminary examinations for felonies. So the felonies are the preliminary examination, or the initial arraignment and the preliminary examination. If somebody is charged by a misdemeanor, and what does a misdemeanor mean? Let's talk about that basically. A misdemeanor means any crime punishable by 1 year or less. The Michigan Penal Code, as well as the Michigan Code of Criminal Procedure, defines a misdemeanor as punishable by 1 year or less, and a felony and is anything punishable by more than 1 year in prison. Okay? Because the county jail, that's the other thing you want to know too.